As a PhD student who has also taken time to study family law as a course, who has looked into examining the Marriage Act, the Matrimonial Causes Act, the Matrimonial Causes Rule, which are rules or laws that regulate proceedings with respect to marriage, how you determine issues with respect to custody of children, settlement of property, maintenance of spouses, as well as other international conventions that govern spousal relationship maintenance, custody at the national or international level. One thing is very constant in these laws, which is what the court will consider when determining issues relating to custody of a child or children of a marriage, or children or a child between a man and a woman. The law has provided that what the law or the court will make of paramount importance is the best interest of the child. And as a PhD student who has also prepared, done seminars on the best interest of the child, I understand this topic or this concept better. 4 things the court will look at: the circumstance of the case, the conduct of the parties, their condition in life, and their earnings in life. These are things that the court will examine one after the other before it comes to that conclusion on who should have custody and the nature of custody that should be granted to the parents of that child or those children. It is true that the social welfare also has a role to play, because sometimes when these disputes come up, even before people get to the courts, sometimes they first pay visit to the social welfare. And it is the responsibility of the social welfare to comply with the provisions of the law with respect to determining issues relating to custody of children. So in taking this decision at the welfare office, consideration must also be had to what is the best interest of the child. That must weigh most importantly on the mind of a social welfare officer in making your reports, in making your decisions, in making rules or regulations as to how a child or children should be taken care of. So there is nothing empowering a social welfare officer to mandate the mother of a child to hand over her 1-year-old son to a man who impregnated her, abandoned her during the pregnancy, and does not even know how she has managed to raise that child up to that point in time, without considering the bond that has existed between that mother and the child. So, does it mean that presently the social welfare office has now taken the front wheel in determining how to grant custody or who should have custody of a child, relegating the provision of the law to the background? That will amount to non-compliance with the provisions of the law. This is Zivial Law Essence. Here we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. We'll see you again.